Susan found herself suddenly widowed, 2 kids under 10. If you're a new parent, some things you need to do now. Today, we're going to talk about one of my clients, Susan, who hired me a couple years ago after her husband, Barry, died. Susan, late 20s, early 30s, office manager at a landscaping company. Barry was a contractor. When he died, Susan knew that her life had changed forever. She and Barry had 2 kids under 10, and she knew that she was facing a life without her partner. She knew that she was now a single mom, a widowed mom, who was responsible for raising those kids. She knew that everything was going to be more difficult. What she did not expect was that the probate court in the county she lived in was going to be her partner in an ongoing fashion until the kids turned 18. Susan and Barry didn't have any planning in place. And we're going to talk about that story. And then I'm going to give you some tips. If you're a new parent, some things you need to do now. Don't put it off. My name's Jim Miskell. Welcome to Let's Talk Estate Planning. This is the podcast for folks that are interested in learning about estate planning. I'm a lawyer, 30 years plus in the state of Georgia. This, though, is not me giving you legal advice. Legal advice happens when you sit in front of an attorney and you get to ask some questions. And you know, the first question you ask an attorney every time, the answer is going to be, well, it depends. And that's not because an attorney's being a smart aleck. It's because the answer really is almost always dependent on some other facts that aren't apparent from your question. And she is then going to ask you some questions to fill in those blanks so that she can give you a good legal opinion and good advice about your situation. All that to say, this is a podcast, and this is for entertainment, education. Well, all right. It's for education and maybe a little bit of entertainment. It's informational so that folks can begin to make some decisions about their estate planning and be prepared to meet with a professional to get good estate planning in place, because that's the best way to do it. Again, all that to say, this isn't legal advice. It's just a podcast, but hopefully you learn something from it. The whole purpose of this podcast is that I dream of a world where everybody's got their estate planning in place so that when grief, crisis, and transitions occur in families get to spend time together supporting each other instead of running around town trying to figure out how to do administrative stuff and dealing with lawyers and probate courts and all that kind of stuff. So let's get right to it. I laid out the basic facts for you. Susan found herself suddenly widowed, 2 kids under 10. Barry and Susan, since the time they had gotten married, had talked about getting some basic estate planning in place a few times, but it always sort of put it off. And that's easy to do. You know, you tell the dentist, I'm going to floss. You take the little trial size floss with you and chuck it in the drawer at home. And maybe you floss a few times that next week, but do you floss every day until your next appointment? I don't know. I got a lot of those little trial size floss containers in my drawer at home, but I'm doing better than I used to. I've strayed from the point. The point here is that Susan and Barry made some assumptions that being married and being parents, that the law would work in a certain way for them. And they were just wrong. I tell folks all the time that there is common sense over here and there is the law over here. And sometimes they look pretty similar, but very often the law works differently than common sense. In this case, Barry and Susan assumed that if something happened to one of them suddenly, as it did, that the surviving spouse would just inherit all their property and be able to move forward with the sum total of their assets and be able to make whatever decision was in the best interest of the family about managing those assets, about how to spend it on the kids, and to raise the kids. Unfortunately, they were wrong. Because in Georgia, like in many states, intestate succession, and this is what we're talking about. If you pass away without a will, without a trust, without anything in place, it doesn't go the way you hope it goes. It goes the way the code says it goes. And what the code says in Georgia is that spouse and kids take equal shares, so long as there's 2 or fewer kids. Spouse never takes less than a third. So all of Barry's property that she assumed would just naturally came to her went into his probate estate because there was no will. She applied to be the administrator of his estate, and that's where we came in to assist her in that process. And she was approved and made the administrator of the estate, but she could not just transfer all the property to herself, and she could not just sign off on behalf of the kids saying that the will looks fine. I've got several episodes that discuss how probate works, but part of it, in case you need a refresher, part of it is the code dictates interested parties in the family that has to get notice of the probate proceeding, whether it's a will or an administration like it was in this case with no will. And that in this case, it's the spouse and kids. Now, the kids under 10, certainly under 18, and not of legal age, so they're incapacitated as far as the law is concerned. And in that case, when you've got incapacitated beneficiaries, incapacitated heirs, underage heirs, then you ask the court, you say, hey, we've got folks that need a guardian ad litem here. And guardian ad litems, they're attorneys appointed by the court to make sure that everything's on the up and up, that those folks who can't speak for themselves legally don't get railroaded. And so that's what occurred in this case. We put the court on notice, hey, we need guardian ad litems here for the kids. And one was appointed just for both kids, representing both of the kids. Some courts prefer to do one for each, but in this case, it was just one for both kids. There's a little extra fee there. It's not really that significant, but it is another fee that's part of this probate process for administration of an estate. In the estate were some accounts that belonged only to Barry. He had an investment account actually from before they got married that he hadn't put together as a joint account. They actually lived in the house that Barry owned before they got married and had never gotten around to changing the deed. So the house was in the estate. And so the idea here is, and the way this property is to be divided, it would be a third to Susan, the widowed spouse, and a third to each of the kids, including the house. Some probate court judges, with an opinion from the guardian ad litem that it's appropriate to give the property straight to the surviving spouse. And that's honestly what Barry and Susan would have contemplated. That's what most folks have in mind. She, again, office administrator, office manager, knew how to organize her thoughts and handle finances. They didn't get married right out of high school. She'd lived as a single person, as had Barry. She had some financial wherewithal and understood how to get things done financially. Rather than the court accepting from the guardian ad litem renunciations of the children's share in favor of Susan, so she would have everything and could raise the kids, this judge said, nah, we're going to follow the code here. We're going to stick to it. I'm going to reject the renunciations, and a third of this money and a third of the value of the house goes in each child's name. This was not reflective of the reality between Barry and Susan, but it was reflective of the reality that the judge had experienced. The judge understood that the law was set up to prevent kids from being impoverished, and he'd seen some bad behavior from widowed parents in the past, so he was erring on the side of caution. Was it necessary in this case? Susan would tell you no. I would tell you no. The guardian ad litem told the judge no. The judge said, well, that may well be, but here's what we're going to do. We're going to do equal thirds. what this meant was that conservatorships were set up for each of the kids. Now, these conservatorships last until the children turn 18. And that's what I meant in the introduction when I said Susan didn't expect to sort of have the probate court be her partner throughout raising the kids, because the money being in conservatorships mean that that's a process overseen by the court. In this case, with this particular judge, rather than Susan being conservator for the kids herself, she accepted a recommendation that the county administrator be conservator for both the kids. What does that mean? That means as far as all the annual reporting that's necessary under a conservatorship for a minor child was handled by the county administrator, who does that all the time. It's easy. All the investments were managed by the guardian ad litem. As much as Susan was capable and managed her own finances and investments, she was okay with just letting the county administrator take this function over for the kids' conservatorships. And her role became just to ask the conservatorship when it was time to spend money for the kids. If the kids want after-school soccer, she would ask the conservator. The conservator would petition the court. The court thought it was okay, would release the funds. Pretty cumbersome process. Think about all the stages the kids go through as they grow. Their school book, school clothes, cars as they turn teens, and then as they look toward college, using the money there. One of the real drawbacks to conservatorships, and I've got another episode or two talking about conservators for underage folks. One of the real drawbacks here is that conservatorships end on the 18th birthday of the child. And when the conservatorship ends, all that money goes right to the child. So not ideal, not what Barry and Susan would have set up, but this is the situation she was in. And so that is how things sort of unrolled. And because the house was in Barry's name, it ended up being in equal thirds. So she was able, there were enough investments, enough in Barry's liquid assets that she was able to compensate. She had to compensate the kids for their thirds of the house so that that title could be unified under Susan's name. And then she had more freedom to make the decisions she needed to about where they lived. And because her income went down. That's the other thing that happens when a spouse dies, is not only is there somebody missing, their income is missing as well. So this is kind of the way things unfolded for Susan. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestateplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So letstalkestateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. We have actually represented another lady in a similar situation, and that house, actually, both husband and wife were actually on the deed, but it wasn't properly set up. In Georgia, you need some special language for there to be survivorship, and some other states that with married folks, they call it tenants by the entirety. In Georgia, it's joint tenants with right of survivorship. When spouses own the house that way and one spouse dies, the survivor continues to own the house alone. It's joint tenancy is sort of multiple owners that own the whole house, and when one dies, there's just one less owner. It's not even really like it transfers. But in that case, where the deed was set up where each spouse owned half of the house, but it wasn't with right of survivorship, in that case, and I'm sorry, I'm a lawyer, I hate to talk math. In that case, you ended up with the kids each owning a sixth of the home, and the surviving spouse owned 4/6 of the home. In that case, there were two kids as well. So that makes the math a little less hard than it could be. But in any event, this is the situation. Why do I tell you this story about Susan? because it was a pain in the neck that continued to go on and on. And although she was comfortable having the county administrator do this because she understood that the judge was really keeping an eagle eye on what was going on here, the drawback to having the county administrator run it, although there was certainly an advantage to that, was that there was extra cost. Because when you've got somebody else managing the money, there's a fee for that. There ought to be a fee for that because it's work. This is not what Barry and Susan would have had in mind. Barry and Susan would have had in mind that all their estate should stay with the family and they wouldn't have to pay a bunch of fees to other people. In this case, was the fee worth it? It was better than not having the county administrator, I suppose, but it sure was a lot more expensive than had they done estate planning, which would have kept all the property in control of Susan, where she could have used that money to raise the kids as she saw fit, and she wouldn't have to go to the court for after-school soccer or back-to-school clothes or any of those things. So I tell you that story about Susan, Barry's widow, and the kids to bring it all down to this. If you are a new parent, congratulations. Man, is it exhausting and it can be overwhelming. My wife and I have raised 3 kids into their teens and early 20s, and I'm here to tell you, you're going to make it. Some days you'll wonder, but you're going to be okay. But as you embark on this journey of being parents, it's even more important to pay attention to the estate planning than it was just as newlyweds. So let's focus on a couple things. First, don't rely on the system. Don't rely on the law being what you think ought to happen. You and your spouse, the other parent, you sit down, talk about how you want this thing to go. If something happened to one of you, and God forbid that it does, but if something happened to one of you, how do you want things to go? Is your answer the same as Barry and Susan, that it should just all stay with the surviving parent? You raise the kids, whatever, you don't need to split up the assets then? For most folks, that's what they have in mind. But one of the great things about estate planning is it doesn't have to be like anybody else's. It doesn't have to follow any particular pattern. If you guys have something else in mind, if you've got enough resources to allocate funds to the kids upon the death of a spouse and you feel like that's the way to do it, by all means do it. But whatever you decide, you need to get your own plan in place because the law and common sense, the law and your values, the law and what's important to you, may or may not do the same thing. So that means a good will plan or trust plan. There are several episodes where I talk about the advantages of a living trust over the will. Just quickly, bullet point, the living trust plan keeps the surviving parent from having to go through any administrative process at the courts while they're grieving. Costs more to set up now, but it costs less usually from beginning to end because there aren't those probate costs associated. So get your plan in place. Part of that plan is good estate planning. Don't forget your disability planning. What do I mean by that? It's easy when we think about estate planning to jump to what happens when we die, who gets our stuff when we die. What's really important to your family now that includes kids is what happens if you get disabled? What happens if you're injured terribly or you become terribly ill and you need help? That's where powers of attorney, healthcare directives are critical as part of your estate plan. So as you think about will or trust, who gets our stuff when we die, that's really important. The other thing is, how's this going to work if one of us becomes disabled? I know this is terribly romantic. I know this is your favorite thing to talk about. I know I'm being sarcastic, but it's worth the time you spend on it. If Susan could go back and do it again, she would have insisted on having the hard conversations and getting it done so that she's not partnered with the probate court through the kids' teenage years. So that's first. Don't rely on the system. Don't rely on state law succession. Get everything in place. Whether you choose to do a will or a trust, don't leave the kids and the families hanging. Second, name guardians. If something happens to both of you, let's say you're in the same car, one of you is killed, the other one is terribly injured, who do you want to step in to be guardians for the kids? This can be important not just when both of you passed away, but also if there's disability. So make sure that you've got guardian nominations in play not only after your death, but also should you become disabled. So Don't rely on state law succession. Make sure you name your guardians. So with your estate plan and your appointment of guardians, I have found that families, this has strongly been my experience, families will do what you want them to do, but they're not psychic. You got to give them direction. So if you want one set of grandparents to be trustees and one set of grandparents to be guardians, everybody's going to go along with that, but you got to let them know. So it's really important to get it memorialized because, again, I can't say this enough times. What you think the law is and what the law actually is may not match. The best law to make is the law that's in your own estate plan that governs what happens should one of you as a parent have an untimely death like Barry. Pay some attention to beneficiary designations. Now, you've been married for a while, at least a minute if you got kids probably, or maybe not. But if you're employed, when you set up your benefits at work, if you did that before you were in this significant relationship, this relationship where you have kids, you might have named somebody other than the other parent to be a beneficiary. You might have named your own parents. Go back to all the beneficiary designations and make sure that they match what your plan is. Your plan is not just who gets it, but how they get it. And so, although beneficiary designations avoid probate, and that might be perfectly appropriate to give to the other parent, also you may want some testamentary trust planning in there. But what I'm urging you here is make sure that they're current and make sure they reflect what's important to you now, not whatever it was when you did it several years back before you had kids. So it's time for a refresh and an adjustment to make sure that they're current. So as a new parent, you've got a wonderful blessing in your life. It is time to sit down with your other parent and have that hard conversation. Get an estate plan in place that protects the family's values, that does it without paying a lot of folks administrative costs that you don't need to pay, and one that reflects choices made so that your family, your kids in particular, can have their best possible future, even if you're not in the picture. And if when you and the other parent sit down to discuss this, you realize that if something happens to us, there's a big hole in our finances. We need life insurance. Now's the time to get that. As important as the estate planning, life insurance is equally important to fund the estate plan, to make sure that the kids have enough money to buy those back to school clothes, a first car that they might need, tuition for college, or money to get them started in life. Life insurance is a great mechanism to provide for that. And also, a lot of folks use it to pay off the mortgage if something happens to one of the spouses, so that the surviving partner doesn't have to struggle with the mortgage with only one income coming in. So it's time to have that date night. It's going to be romantic. It's going to be wonderful. You can do it while you're walking the dog or drinking a glass of wine, but power through this. Once you've decided what you want, call a qualified estate planner in your area, sit down with that attorney and say, this is what we've laid out. This is what's important to us. What's the best thing to put this in place? Should we do a will? Should we do a trust? Here's sort of a picture of our assets. Here's who's important to us. Here are the friction points between the in-laws. How do we best memorialize what we want to do? Because that is what qualified estate planning attorneys do, experienced estate planning lawyers do for you, is they can bring their own experience to bear. And they've seen a lot of plans done a lot of different ways for a lot of different families, and they'll have great input for you on that. If you're in the state of Georgia and you want to consult with an attorney about your estate plan, hit us up on the website, letstalkestateplanning.com. It's the same as the name of the podcast. Just let's keep it simple, right? Letstalkestateplanning.com. Would be happy to discuss with you the things that are important to you and make sure you've got a plan in place to make sure that those important things are the drivers of the decisions, not administrative hassles, not convenience, but making sure that your family has its best possible future, even if you're not a part of it. Thanks so much. I really appreciate your time. I'll look for you on coming episodes of Let's Talk Estate Planning, and I hope you have a fantastic day. Take care.